Okay, so whenever you'd like to begin, we're all set.
Thank you, everyone. Welcome to our program today for the National Electrical Contractors Association, or SETS Association Antitrust Law Training. My name is Jeff Tenenbaum. I am the managing partner of the Tenenbaum Law Group based in Washington, D.C. We are a three-lawyer boutique law firm focused exclusively on the representation of associations and other nonprofit organizations, primarily as outside general counsel. I have been doing this same sort of work, an attorney in private practice in DC, representing associations for the last 25 years. And among many other areas of law that I focus on and that we focus on as a firm, antitrust has always been a key area of focus for all trade and professional associations, including National Electrical Contractors Association and all of its various components. And so I have deep experience counseling associations on the issues that I'm going to be talking about here today from all different perspectives, and hopefully that'll help inform the discussion. But I really want to encourage you guys to ask questions throughout by posing questions to me in the either the chat or the Q&A box. I'm not sure if one is disabled or not, but wherever you can pose questions, feel free to, and Melissa will kind of pose those to me as they pop up. I have a fairly good amount of material to cover today, but I want to make sure that I really am able to explain in a way that makes sense to all of you the key issues that you guys need to understand. So if there's anything you want me to talk about more, go into more detail, or if you have examples or specific questions based on your experiences, please feel free to ask at any time. So here's the agenda of what I am planning to cover today. I'm going to give you some antitrust law basics, talk about the application of the antitrust laws to associations like yours in a variety of different areas. And then toward the end, talk about association antitrust compliance programs and the importance there, and finally take any additional questions. But don't wait till the end for your questions. Feel free to ask them throughout. So here's the, let me move this. Here's the basic construct of the antitrust laws. So the antitrust laws, and I'll talk about specifically where they, how they're codified into law at the federal and state level. But the basic idea behind the antitrust laws is to prevent competitors or groups of competitors from obtaining the power to control a market through means other than competition on the merits. These laws are designed to foster fulsome competition, with the idea being that when you have competition between competitors, in this case, electrical contractors, that should benefit consumers with lower prices. What the principal antitrust laws prohibit is concerted action. And that's a really important concept. Competitors can do whatever they want from an antitrust law perspective individually, acting on their own in a non-concerted manner. But when two or more competitors engage in some concerted action, that's the initial prerequisite that can give rise to antitrust violations under what we call the horizontal antitrust violations. And horizontal meaning two or more competitors kind of at that same level engaging in anti-competitive concerted action, as opposed to, say, vertical antitrust violations, which generally relate to things like mergers, which we really don't deal with much in the association world. Because associations are by definition combinations of competitors like yours, one element of a horizontal antitrust violation already exists. And that's the reason why associations have historically, for the last 120 years that the antitrust laws have been around, have been a constant focus of antitrust scrutiny by antitrust regulators at the federal and state level, as well as by private plaintiffs in litigation. So what are the various antitrust laws that exist? Well, first off, the principal antitrust laws that apply to associations and association activity are Section 1 of the Federal Sherman Antitrust Act and Section 5 of the Federal Trade Commission Act. And then every state has their own antitrust laws that largely mirror these laws, particularly the Sherman Act. And most of the issues that we deal with in the association world and the antitrust area relate to these two laws. Other laws that sometimes come into play, the monopolization provisions of Section 2 of the Sherman Antitrust Act. Mergers are regulated by the Clayton Antitrust Act, and oh, by the way, when I referred to vertical antitrust violations, I was referring to monopolization. I think I misstated and said mergers. And then, although mergers definitely come into play as well on the vertical side. And then finally, the Robinson-Patman Act, another federal law, regulates price discrimination. So what does Section 1 of the Sherman Act say? Well, it's a very brief statute. It's not very long or detailed. It has been interpreted hundreds of times by various courts, including the U.S. Supreme Court, and that's kind of the body of antitrust law under the Sherman Act. Really comes from court decisions, especially U.S. Supreme Court decisions that have interpreted this sentence. Every contract, combination, and form of trust or otherwise, or conspiracy in restraint of trade or commerce among the several states or with foreign nations is declared to be illegal. And the operative words here are every contract, combination, or conspiracy. What this has been interpreted to mean is that for there to be a horizontal antitrust violation, there has to be an agreement among competitors, two or more competitors, to do something anti-competitive. But there doesn't have to be a formal written agreement. There doesn't have to be a formal oral agreement. An agreement can be implied based on conduct. Generally, for instance, the principal, the most serious antitrust violation in the association space is something called price fixing, where two or more competitors are agreeing on prices to be charged, whether it's higher, lower, keeping prices the same. Any agreement amongst competitors to fix prices is the most serious, what's called per se violation of the antitrust laws. But you don't have to prove an actual agreement. You can look at conduct between competitors and infer that an agreement took place. So actions of an association are often taken as evidence of an agreement amongst the members of the association to take that illegal action. And even actions of an individual working for the association can be evidence of an agreement among the members of the association. In restraint of trade or commerce, what that basically has been interpreted to mean is that does the agreement harm competition? Does it somehow inhibit full and free competition amongst competitors? And there are two standards that the courts have enunciated, the U.S. Supreme Court in particular, for how to analyze whether an agreement harms competition. The first are those that are deemed to be per se illegal. And what that means is that the violation is so serious that it doesn't matter what the justification is, what the good reason you might have for entering into an agreement. Even, for instance, if you were agreeing, two or more competitors were agreeing to maintain lower prices than are currently being charged or whatnot, that's still illegal. So it's in a per se violation, it doesn't matter the justification, it's automatically illegal. And so, of course, those sorts of anti-competitive agreements are the most serious in analyzing antitrust violations. Most, though, conduct of associations that we deal with, and a lot of stuff I'm going to get into, is analyzed under what's called the rule of reason. And I'll explain what that is. So per se agreements are those agreements that always or almost always restrict competition and or reduce output. Here are kind of the leading in the association world, kind of the leading types of per se illegal agreements. Price fixing, which is, again, two or more competitors agreeing not only on prices or fees to be charged, but any components of price or price-related terms like discounts, credit terms, trade-in allowances, et cetera. Anything that factors into price, including, by the way, salaries and compensation. Agreement amongst competitors, to agree on, we're not going to raise staff compensation above a certain level, things like that. That can have an impact on price, and that's deemed to be a per se violation as well. Market allocation is another. That's where two or more competitors agree to stay out of each other's markets so they don't compete against each other. Bid rigging is where parties agree to not bid against each other. Some group boycotts, particularly those where competitors get together to enforce a price fixing agreement or harm a rival. So say, your particular association really doesn't like this one contractor because they're just known as being a constant price cutter and undercutting prices of everyone else. So you decide to kind of boycott them, to kind of kick them out of the association or not let them in or not let them exhibit at your trade show or whatever, not participate in a valuable program or activity of the association. If it's a group boycott that is designed to enforce a price fixing agreement or harm a rival, that is sometimes analyzed under the is deemed to be a per se violation, and then some exclusive dealing arrangements, but most are analyzed under the rule of reason. Per se violations like price fixing, market allocation, and bid rigging can be criminal, leading to jail time for those found guilty. And association has sometimes been used as cover for criminal antitrust violations. Criminal antitrust violations are enforced by the U.S. Department of Justice Antitrust Division, which I refer to here as DOJ, as well as state attorneys general. The two principal federal antitrust enforcement agencies are here, the U.S. Department of Justice Antitrust Division and the Federal Trade Commission. But the FTC, the Federal Trade Commission, does not have authority over criminal antitrust violations, only civil. Criminal penalties can be severe, including incarceration for individuals and fines of up to $1 million for individuals and $100 million for organizations, including associations. All antitrust violations can often result in civil violations, and most antitrust enforcement is on the civil side. Enforcement is, again, by DOJ's Antitrust Division, the Federal Trade Commission, state attorneys general, and then what we call a private right of action, meaning, say, a competitor who is harmed by an antitrust violation can bring a private lawsuit in civil litigation, not criminal. That can only be enforced by, again, DOJ or the state attorneys general. But in the civil side, individuals can bring private litigation. And if they're successful, they can generally recover triple damages. So whatever damages they prove they suffered as a result of the antitrust violation, they can triple that, plus get their attorney's fees covered as well. And civil suits are often brought by aggrieved competitors. The rule of reason. So what is this? It's essentially a balancing test to look at the what we call the restraint, the anti-competitive restraint, whatever and we're going to get into a lot of details, examples of this, but it's basically a balancing test to say, on balance, does the restraint more promote competition or suppress competition? So you look at the restraint itself, the specifics of it. You look at the market power, meaning how much market share of the companies imposing the restraint. And then you also look at potential efficiency justifications for the restraint, as well as sometimes other justifications like health and safety, environmental protection, consumer focused and consumer beneficial factors are sometimes taken into consideration in the rule of reason analysis. So for instance, if this is very common in the association world, and including in kind of the electrical world, it's common for certain associations like the National Fire Protection Association to issue standards that electrical contractors and others in kind of the electrical space have to follow. Now, those standards might have some anti-competitive effects, meaning it might keep some products off the market or things like that, but it certainly has a lot of very beneficial effects in terms of health and safety, protecting consumers, providing standardization so that everyone's kind of working off the same standards. It makes kind of the market work more efficiently. So, you do that balancing, and generally speaking, the courts have generally said that things like, industry standard setting by trade associations, certification and accreditation programs, things like that, generally promote competition more than they suppress it. So, let's talk about liability for the association. And I want to, it's, as you probably can already gather here, there's potential liability for the association for antitrust violations, but there's also liability for the individual members who might engage in these anti-competitive agreements and conduct and whatnot. But here, focusing on the associate, and sometimes the actions of the members can be attributed to the association, and both can be held liable. And if you're going to, for instance, get hit with a private lawsuit, it's probably going to be brought against the association as well as the individual members who have alleged to engage in the anti-competitive conduct. Where the association directly violates the Sherman Act, such as negotiating prices on behalf of its members, or expelling or denying a member for being a price cutter, or facilitating, say, market allocation or bid rigging, the association can clearly be held liable. And there's a 1985, I believe, U.S. Supreme Court decision called Hydro Level versus the American Society of Mechanical Engineers. It was a case where essentially kind of a standard setting committee was hijacked by one of the members of the association who essentially pushed through a standard that benefited his company because his company held a patent to certain technology that once the standard was adopted, everyone else in the industry had to pay a licensing fee to license that patent from the from that member. He didn't disclose that to the standard setting committee that he was the chair or vice chair of, I can't remember exactly. But in the end, in the case went up to the U.S. Supreme Court, the association took the position, look, this guy was acting, outside the scope of his authority. He did not have the authority to do what he did. We never would have authorized that. And we, he might be held liable for some illegal conduct, but we as the association should not be held liable. What the U.S. Supreme Court said is that because he was acting, the member was acting with the apparent authority of the association, it appeared to others that he had the authority of the association, that the association was to be held liable for that. What the court said is that it imposes on the association an obligation to regulate its members' conduct. He was using like association letterhead stationery and things like that to seemingly have the authority of the association, even though he did not. But because it was reasonably apparent to third parties that he had the authority, that the association was held liable for that conduct. So that apparent authority concept doctrine is important to keep in mind. And then where association members use the programs, activities, or facilities of the association to engage in anti-competitive actions, such as using the association's online forum to discuss member pricing issues or the capping of employee salaries or not doing business with a vendor, those individual members can be held liable for antitrust violations, but so can the association, which is why we're going to talk a little bit later about the importance and critical importance for associations to be monitoring things like online forums. And I deal with this all of the time. Even yesterday, I had an email from a client said on our online forum, members were having, they sent me an excerpt of the email trail on the association sponsored listserv or forum, online forum. And the executive director was asking me if it was problematic from an antitrust perspective. And sure enough, some of the discussions were problematic from an antitrust perspective. So I advised her that she needs to take down those discussions from the forum and kind of warn the members about the problematic content. And there, it's not like this happens all the time. The members weren't trying to do something bad. They were basically asking, in the COVID era, what are you guys doing, in the coming months in terms of staff compensation and salaries and whatnot. It was a legitimate good faith inquiry, but very problematic from an antitrust perspective. And what I found, and part of the reason why we're doing this training here, is that a lot of these antitrust concepts and principles are not intuitive. If you don't know this, if you're not taught this and read this, learn it, hear it, you don't automatically know that that's illegal. It's not like it's intuitive to most people. So it's really important. That's why we do these staff trainings. That's why I do a lot of board trainings and volunteer trainings in the antitrust area as well. In terms of personal liability, certainly, as the second bullet point says, there may be personal liability for those who participate in or knowingly approve of an antitrust violation. But generally speaking, if you're exercising your fiduciary duties, exercising ordinary reasonable care and performing your duties, showing honesty and good faith, not engaging in conflicts of interest that are harmful to the association, and not engaging in anti-competitive discussions or actions, generally you should not be held personally liable. So these are kind of the principal areas of association activity that give rise to most of the typical antitrust violations in the association world. So I'm going to talk about each one of these, some more than others, but these are kind of the principal areas of focus. Some of these are going to be relevant to your association, some are not. And I'm going to try to just spend most of the time on the ones that are most relevant to you guys. So discussions at meetings. Proof of an anti-competitive agreement that violates the antitrust laws can start with proof of parallel conduct by competitors, along with potentially illicit communications between rivals. And because association meetings generally involve communications between rivals, you have to take great care to avoid illicit communications. And I say illicit because sometimes a conversation, just like the one I cited a minute ago about kind of the association's online forum, the discussion alone doesn't mean, okay, there's an antitrust violation and someone's going to be held liable. But it's the first step in proving an antitrust violation. So, it's been a best practice for decades for associations to try to nip this stuff in the bud and not even allow those problematic discussions to occur. Obviously, on an online forum, it's much easier to see and to stop and to take down and to regulate and warn people and discipline people if they violate those rules. But what you also have to do is at meetings, whether it's virtual meetings like most associations like yours are having right now, or back to in-person meetings, and it's oftentimes at in-person meetings. It's not. Sometimes it's in the actual boardroom. I've been in many association board meetings where they have me there because there's some really sensitive antitrust sensitive topics being discovered, and we want to make sure that the discussions don't veer down a path that's problematic. But a lot of times it happens, at the cocktail reception or the dinner or at the bar after the event, after the dinner, things like that in the hotel. And all of those things have been kind of breeding grounds for potentially problematic discussions. And so because of that, it's been a best practice to kind of formalize discussions at meetings through agendas. So it's one of the reasons to have agendas that lay out the topics that are going to be discussed and sticking to those agendas to the greatest extent possible. But what's also become a best practice, I'll talk a little bit later about adopting an antitrust compliance policy, having your board adopt an antitrust compliance policy. But at some of my association clients, and in some associations, at the beginning of every board meeting, and sometimes even committee meetings, like executive committee meetings, they will read like a 1-paragraph antitrust compliance statement that says these are the topics that are off limits for discussion of prices, fees, things that go into price, things like that, to remind people about what is off limits. And it's also helpful from a prophylactic perspective if the association itself is trying to avoid liability later for some problematic discussions. The association can show that it warned everyone about problematic discussions. And then if something does occur, it engages in some corrective action, warns people, shuts it down, etc., then it's going to be very hard to hold the association liable. Other things you should do to help mitigate liability in this area: have agendas and presentations reviewed in advance by legal counsel, at least those that are antitrust sensitive, distributed in advance of meetings. As I said, reading antitrust guidance at the outset of meetings or calls, and including whether it's that 1-paragraph statement or your antitrust compliance policy in all like board materials, board books, things like that. Try to stick to the agendas and materials to the greatest extent possible. Taking minutes of the meetings that concisely reflect the discussions, especially where those discussions might veer off of the pre-prepared materials. And then it used to be common for lawyers and association attorneys to be present at all, for instance, association board meetings. That is not the norm anymore. It's not the best practice. It's really not cost effective. I don't encourage that. But where there are antitrust sensitive topics on the agenda, then it typically is important to have legal counsel present.
So Jeff, we do have one question.
Sure.
What about associations getting involved in PLAs, project labor agreements, with our union counterparts? The Non-Union Builders Association says PLAs and influencing politicians stifle competition.
I am not a labor lawyer, so I'm not terribly familiar with what you are talking about. I will say that one thing that has come up over the years many times is that labor unions have a different status under the antitrust laws. They're exempt from the antitrust law. So if you are classified as a labor union, you can engage in collective bargaining and other things that a professional or a trade association like yours is not allowed to do. Right? If your members all got together and agreed, on prices or fees or compensation or whatnot, that would be highly illegal under the antitrust laws, while a labor union is allowed to do that because of its labor union status. So I have had to warn a lot of associations in the past that don't understand that distinction, don't understand that there is no trade association exemption from the antitrust laws like there is for labor unions. There are ways for an association to get involved in certain things like that without tripping up over the antitrust laws. But in general, you have to be extremely careful in that area because it presents a really high degree of risk. But I'm sorry, I can't get into the substance of that specific example. Maybe Jeff can speak to that.
Yeah, I'll just add to that when you're talking about a PLA, remember that that's the member contractor that's signing on to the PLA and agreeing to do the work at Davis-Bacon wages or whatever the PLA is saying is the prevailing wage in that area. And that's not an antitrust issue from our association perspective.
Right. Okay, that clarifies it. That's exactly right. Okay. Off-limit topics where discussions can lead to illegal agreements under the antitrust laws. Always want to start with pricing, including any discussions of pricing methods, strategies, timing, discounts, advertising, or what constitutes a fair or reasonable price. Whether to do business with certain suppliers or vendors, customers, competitors. Very dangerous under that group boycott prohibition. Complaints about the business practices of other companies, because that can lead to group boycotts. It can also lead to, outside the antitrust area, two other areas of law that come into play here: defamation and tortious interference with business relationships and expectancy. These are two areas where, when you start to veer down the path, using an association meeting or forum to, talk trash, to talk badly about business practices of certain members or whatnot, is very risky from an antitrust perspective, as well as a defamation and tortious interference perspective. And generally, it needs to be avoided. And then confidential business plans regarding output decisions, like, what kind of services you're going to provide. Any limitation on output, meaning any agreement for a contractor to not provide certain services, if there's an agreement by two or more competitors in that regard, can be illegal under the antitrust laws. Again, individual members, competitors, can do whatever they want on their own, but engaging in concerted action, doing it with other competitors, is where it gets problematic. Discussions of employee compensation, as I talked about earlier in some examples, marketing plans, or decisions regarding future product or service offerings. So let's get into another kind of specific area that I believe that NICA is involved in, and probably some of your associations as well. It's a common activity for associations to engage in statistical reporting, surveys, and information exchanges. It's kind of a logical role for associations to play. Historically, it's been a major activity for a lot of trade and professional associations. But because this sort of surveys and information exchanges by an association can potentially trip up these three things: price fixing, agreements to restrict output, and market allocation, you have to be very careful in this area. It can lead to per se violations as well as rule of reason violations. As a result, what in most industries where there is kind of information exchanges, statistical reporting, surveys, things like that, they're often done, and it's a best practice, and there's a legal reason too that I'll get into, why it's often done by associations like yours as opposed to by the members directly. And the idea is that you wanted to avoid any direct contact between competitors. Very important from an antitrust perspective. So what issues are you going to be focused on here as a kind of a third party for such communications, acting on behalf of your members? You're going to look at the type of information, price versus cost, current versus older information, specific as to parties and transactions versus being more general and aggregated. And you're also going to look at the purpose of the information reporting. If it's being done for anti-competitive reasons, it's going to be problematic. So in short, you want to be able to articulate pro-competitive reasons for the information exchange, and that's generally not hard to do. But this is the most important slide here. And this is a safe harbor that's been around for at least 2 decades now. DOJ's Antitrust Division and the FTC issued guidance years ago that they've kind of updated a number of times over the years, I think most recently in 2000. It was guidance that was issued for the healthcare industry, but they said it's applicable to all industries. And it relates specifically to this kind of statistical reporting and information exchanges, including by associations. And the purpose of it is to make sure that companies cannot derive information about their competitors from whatever information is being gathered and kind of pulled together and then spit back out in terms of reports and surveys and things like that. So here are kind of the 4 elements of the safe harbor. And if you do these things, then you will be deemed to be covered by the safe harbor. It doesn't necessarily mean that DOJ or FTC or private plaintiff could not hold you liable for an antitrust violation, but it's going to make it very difficult for them to do so. And so this has most definitely become the best practice in association information exchanges. First, you want to aggregate the information and not include individual company data. So protect that raw data. Only the association staff or if you're outsourcing into a contractor or a vendor, should see that data. When it gets spit back out to the association members, it needs to be aggregated. Another point, very important, it has to be older data rather than current or forward-looking data. And DOJ and FTC says that means it has to be at least 3 months old. So you can actually do statistical surveys and information exchanges about prices or fees charged by your members, but the data has to be at least 3 months old. You cannot ask about current data or about future plans, future data. And then third one, also very important, you have to be sure there's enough companies or members participating so that it's not possible to determine whose data is whose. And what they've said is that you want to ensure there's at least 5 companies in each category of data, and that no company's data accounts for more than 25% of the total in that category. Because where there are only a few companies in an industry, for instance, it's going to be easier to pick out their data from the distributed information. And then finally, this is obviously great for associations, have a third party, such as an industry association, manage the process without any involvement from the member companies. And then 2 things that I've added here. You always want to make sure you avoid any unregulated discussions about the results and data by the members, and you want to consult with legal counsel both prior to and during the process. Okay. The group boycotts, again, sometimes called a concerted refusal to deal. Again, it's another one of the violations of Section 1 of the Sherman Act. These are the types of association activities where this stuff typically comes up. Self-regulation and codes of ethics and codes of conduct by the members, kind of regulating the members' business activities, standard setting, certification, and accreditation programs, membership requirements. Basically, if you were to deny someone a membership or kick someone out of membership, or take some disciplinary action against a member, that has sometimes, in some cases, been deemed to be a group boycott. Providing access to association services and activities, especially to non-members, and online member forums. Some of these things could be illegal per se, but most are looked at under the rule of reason, unless the boycott is enforcing a per se violation, such as you're kicking someone out of membership because they're a price cutter. Then it's going to be a per se violation. In terms of membership requirements and kind of the expulsion or denial of membership, like I said, they're looked at as potential group boycotts. The rules and decisions on membership and expulsion are generally considered under the rule of reason. Exception if the decision or rule relates to access to some business input that is essential for effective competition, and if there's no plausible justification stemming from the association's pro-competitive purposes. And I already talked about the last bullet point there. Under the rule of reason, what we're looking at is to see whether we're looking to see the effect of the requirement or decision. There's a number of factors that we focus on in this analysis. Number one, are the rules objective and consistently applied? So are they, whether we're talking about membership criteria in bylaws, outside of the bylaws, whatever the case may be, are there objective rules where you can, be able to look at them and apply them on an objective and consistent basis? If the rules are subjective, is there a legitimate reason for the rule based on the pro-competitive needs of the association? So this is very important. When you are applying your membership standards, there are some, it's not a best practice, but there are some associations that still have their board or a membership committee voting as to whether someone can or should be admitted as a member to the association. It's generally a very disfavored practice because the membership standards should be so objective that staff should be able to look at a membership application and see whether someone qualifies. If it's too subjective or it's not going to be able to be applied consistently, it doesn't automatically mean it's going to result in a group boycott, but it creates a more risky situation. And then it's always important to provide some due process, especially for those who are expelled or denied membership. And the courts generally seem to treat expulsion, so taking someone who's an existing member and expelling them from membership, they basically say that requires an even higher level of due process. And what do we mean by due process? Nothing specific, but things like, having a hearing. Like I have a client, an association client, that is going to be having a hearing coming up at the board level as to whether to expel a member. And what I've advised them is, we're not going to create a full-blown court-type proceeding, but it's going to have some elements of that. Where the executive committee is going to kind of make the case, proposing expulsion by the association's. It's going to make the case to the board. The board is going to be the one making the decision. The executive committee is going to present its case. It's going to provide a number of examples as to how the membership rules and standards and code of ethics were violated. It's going to call several witnesses. And then the member whose membership is up for potential expulsion is going to be provided an opportunity to defend himself, to make arguments as to why he should not be expelled, to call witnesses if he wants, to have an attorney participate. It's going to be a virtual hearing. And then the executive committee's representatives are going to have a chance to rebut the case made by the member. And then in the end, the board will make its decision. In some cases, so you want to provide the member with notice and an opportunity to respond. We're going to work with the member to make sure we find a date that works for him. Sometimes you don't have to have an appeals process, but some associations do. Have another body to which the decision can be appealed. Again, not an absolute requirement, but I just want to flag it. Some associations do that. And then, of course, make sure that whoever's making the decisions has no conflict of interest. If there's anyone on the board that has a conflict of interest, maybe they do, they have a business partnership with the member at issue or something like that, they would not be disinterested, so they should be recused from the process. Services to members versus non-members. So here's the bottom line here. There's been a lot of court decisions in this area, and I get this question a lot. Can we require someone to be a member before we provide certain services to them? And the services could be ability to attend a conference, ability to exhibit at a trade show, ability to participate in an online member forum, or other things as well. The short answer is that unless the service that the association is offering is what's called an essential facility, meaning that access to that service is essential in order for the member to effectively compete in the relevant market. For instance, the example of a certification program where you really can't legally operate in that world, in that profession, in that industry, unless you're certified or accredited by the association. That's an essential facility. In those situations, you have to make that available to non-members as well as members, although you can certainly charge a higher price to reflect the fact that they're not paying membership dues to subsidize the program. But most association programs and services are not essential facilities. We would all love for them to be, but they're generally not. And so if it's not an essential facility, you can require someone to be a member first before you provide them access. General guidelines in this area: take a look at the services periodically to see if they are essential for effective competition. Make sure that services like that are made available to non-members. Even if the service is an essential facility, as I said, you can charge a higher fee to non-members. And the antitrust risk is going to vary depending on how valuable the services are. Same basic concept goes with respect to trade shows, especially once we get back to in-person trade shows. Generally, a rule of reason analysis. If you have rules for who can participate, even rules on favorable placement, in an exhibit hall, if you have limited space, you can have rules that kind of limit who can participate, but they need to be objective and reasonable, and they need to be objective and consistently applied. So for instance, if you give precedent to prior exhibitors, like a lot of associations do, if there's limited space, or you give preferential space location in the exhibit hall, based on prior exhibiting history with the association, that's okay, because those rules are objective and reasonable as long as you apply them on an objective and consistent basis. Some don'ts in this area: do not apply your rules in a discriminatory, inconsistent, or subjective manner. Certainly don't base your decisions on whether the company engages in competitive pricing. Don't condition decisions on whether a company agrees to appear at a competing trade show. So don't say, we're not going to give you access to this unless you agree not to, exhibit at some competitor's trade show, competitor association or whatnot. And don't use subjective criteria for participation or allocation of resources. In terms of the regulation of member conduct, often referred to as a code of ethics. Sometimes these things might actually be in the bylaws, but oftentimes it's a separate document called a code of ethics or a code of conduct that regulates kind of member activity. This is very different from what's become more common these days, kind of event-based codes of conduct or codes of conduct for participation in online forums or things like that. That's different from what's often called a code of ethics, which is basically trying to regulate members' business behavior outside of the association, just in a day-to-day course of its business. There are two types of codes of ethics from a legal perspective: aspirational codes and enforceable codes. An aspirational code, just like the name suggests, means we encourage our members to aspire to meet this code of ethics, but if they fail to, we don't take any adverse action against them. Whereas an enforceable code, as the name suggests, means if we get a complaint lodged that a member violated the code of ethics, then we actually do some sort of an investigation, look into it, and even have a hearing and decide what sort of adverse action should be taken against that member. Those are fairly common in the association world. There's a lot of court decisions that say that this sort of self-regulation by associations can be beneficial and pro-competitive. And most court cases in this area have upheld this sort of regulation of member conduct from an antitrust perspective. But there have been some. There was a notable U.S. Supreme Court decision involving the California Dental Association a few years ago, that held that the code of ethics of the California Dental Association violated the FTC Act, Section 5 of the FTC Act, because it limited truthful advertising by dentists. It was about dentists offering kind of non-dental services like whitening services for teeth and things like that. And the court held the code went too far, and it limited the ability of dentists to engage in truthful advertising, and was therefore illegal under the FTC Act. The association ended up entering into a consent decree with the FTC. But here's where, like in the CDA, California Dental Association case, where code of ethics can be anti-competitive. Not usually, but in cases where there are restrictions on truthful advertising, especially relating to price, restrictions on competitive bidding, restrictions on the business hours of members, on the opening of new business locations, on business relationships with vendors or suppliers or competitors, restrictions on fees set by members, or restrictions on output by members, like not an agreement or a prohibition on offering particular products or services. But again, this is generally going to be analyzed under the rule of reason. I talked a little bit about association-sponsored online forums for member communications. Same basic construct that exists for in-person or virtual board meetings and committee meetings and other things like that. It's just that we tend to see more problematic discussions and statements by members on these online forums than we do in other settings. It happens, I deal with it all the time. It happens more than you might think. And so what are kind of the best practices for how to deal with this? Well, one, you want to have rules, kind of terms of use, so to speak, rules for participation in the online forum. There's a lot of non-antitrust related issues you're going to deal with there. Things like, don't post anything that infringes anyone's copyrights or trademarks. Don't post anything defamatory. Don't post anything that invades someone's privacy. Don't use the forum as a vehicle to sell your products and services, things like that. But then you also want to have the antitrust component of it. Here's the things that you cannot discuss. Here's the problematic topics of discussion. And then you want to have all participants in that forum click and accept that they agree to those rules, those terms of use, before they initially are allowed to use the forum. And then it's generally best practice to send out, at least to all participants in the forum, a copy of those rules every year as a reminder. In addition, while you don't need to have someone screening every post before it goes up or whatnot, like a moderator, because some of these posts can give rise to antitrust liability, as well as other types of liability, like I just mentioned, including defamation, tortious interference, copyright infringement, etc. You want to have these forums generally monitored, by well-trained and responsible staff, so that if staff sees something, if you guys see something that's problematic, you can run it by your legal counsel, you can run it by Jeff Fagan, general counsel to Nika, or whatnot, and see whether you need to take it down in that example I gave you earlier, and perhaps a discipline and whether it's slapping the hand or something worse. And we've had situations where some members are kind of repeat offenders on the forums and are using them in really problematic ways. And we've actually, worked with associations to, suspend, that person's access to the forum for a year, things like that. Lobbying, basic thing to take away here is that lobbying is generally exempt from the antitrust laws due to the First Amendment. So if you're engaging in bona fide lobbying of, say, a federal or state legislature or a federal or state agency, even if you are lobbying on behalf of some anti-competitive, a law or regulation or something that you're pushing for, if it's bona fide lobbying under what's called the Noor-Pennington Doctrine, it's exempt from antitrust liability. But there have been some cases that found where the lobbying was really a sham, and the lobbying itself, rather than the governmental policy that you're lobbying for or against, has an anti-competitive effect. It can form the basis of an antitrust violation, but that's rare. Home stretch here, antitrust compliance programs, very important. The hallmark of an antitrust compliance program is an antitrust compliance policy. And so you want to have a board approved policy. I believe that Nika has one. I have some samples and models if you need them. But you want to have your board adopt an antitrust compliance policy, more than just a one paragraph statement that you might read at the beginning of a meeting, but a more detailed policy that basically says, we, the association, have adopted this policy and we don't tolerate and don't engage in this sort of anti-competitive behavior, and we don't allow our members to. And it's very important, to help remind the members about what's off limits and what's problematic, but also prophylactically, if you have a board approved antitrust compliance policy and you enforce it, then even if you have some bad actor or rogue members that engage in some problematic discussions or activities, it's going to help to inoculate the association from liability. You should have the board adopt and affirm the antitrust compliance policy, include it in all board books. I talked earlier about, in some cases, reading that short antitrust compliance statement at the beginning of certain meetings, or maybe all meetings, having legal counsel present at a meeting where there's antitrust sensitive agenda items, having legal counsel do an advanced review of antitrust sensitive documents, programs, or activities, and like we're doing here, do antitrust training for association staff, boards, and sometimes other leaders as well. So that is the end of my prepared remarks. We have about 10 minutes left till the top of the hour if anyone has any questions.
Any questions? Jeff Fagan, would you like to add anything?
Yeah, I just want to thank Jeff for coming back on here. He does a great job with this presentation, and it's something that I will be enforcing and reinforcing, as we move forward. Jeff and I were colleagues at his prior firm, and he's, as he told you, he's the nonprofit guru in this country, and we appreciate him coming on with us.
Thanks, Jeff. All right, thank you guys. I appreciate your time and attention, and hope you have a good rest of your day.
Okay. Thank you very much.
Thanks, Jeff.